Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. Have you recently been served with an application to the court about property or children's matters? Well, then this episode is for you. We've had many listeners writing in asking, what do I do? What does it mean? And today it's your opportunity to have Mum here answer those questions for you. And we're going to talk you through the process of what it means and what you need to do. Hello, Mum.
Hello, Laura. Hello, everyone. It's nice to be back on air.
It is. Welcome back. It's been about a month. Mum's been sick. She lost her voice for 2 weeks, and then I got sick. And yes, it's been pretty rough for all of us, but we are through the worst of it, aren't we, Mum?
So, we're a bit croaky and a bit rusty, but yes. But people have been saying,
so please forgive us.
Where are you? Where have you been? So that's where we've been.
So don't worry, we'll be back every week. And this is going to be a series of episodes that we're going to do because as we've been talking to and being involved in some of the domestic violence charities, a lot of the social workers have said to us, haven't they, Mum? Half of our job at the moment is helping women fill out these forms. Yes. So hopefully if anyone's out there who's been served with the document and they don't know what to do, this is general advice, but Mum can talk you through a little bit of what you need to think about and what's going on. So let's get into the nitty-gritty of it, Mum. First of all, what does being served mean? So what does that mean exactly?
So being served means you've been given the documents in a way that the court recognises that you would know the court events on, you know about the documents. So it's just whoever gives them to you, however they get them to you, has to prove that you know about the court case.
Most services are done through email.
A lot of them are. You have to say you're going to accept service that way, but you still get the odd process server, they call them, who would turn up at your house, knock at the door, you go to the door and they say, are you such and such? And you go, yes. Well, I have these documents for you. And I can tell you that's a heart in your boots moment because you've got no idea what's coming when you open those documents. Yes. So I kind of thought, Laura, that a podcast like this, even for people who aren't at that stage, might help soften that initial shock for them. Yes.
And maybe know what's coming because maybe you've tried mediation and it hasn't worked and you've been given your certificate saying you tried, which usually if you can't agree and mediation's not working, that is the next step. So this may be coming. And I did see recently, it was about 2 months ago, a famous American actress was doing a TED Talk or something at something and the server served her mid-speech.
Oh, my
gosh. That's horrible. And I don't know if that will happen in Australia.
No, you're not allowed to normally serve people at work. It's a bad form to serve them at work. And you never can serve them in the court precincts. But usually they'll get you at home on your way to work or in the car park.
But it's good to be served because you'd hate to not know that there was a court event happening or not be prepared. So even though it sounds scary in a way, it's good because they have to prove to the judge that you knew about it. And if you choose not to do anything about it, that's your choice. Bad choice.
Well, not always.
At least.
not always. With someone.
Okay, well, let's get into that then, Mum. So, so you've been served with, and we're just dealing with at the moment, an application to the court about children or property matters. What is it? Okay. So it's actually called an initiating application?
So you open up the envelope, if it's in an envelope, and there'll be a letter to you saying we are enclosing these documents. And the first one will be an initiating application. And it might be for property, might be for children, might be for both. I don't know. And it'll generally have an affidavit with it. Sometimes if it's property, it'll have a financial statement. It'll have a parenting and financial questionnaire or just a parenting questionnaire or just a financial questionnaire. A notice of abuse. There is a lot of documents. It'll be half a ream of paper probably. But
what does it mean? What does it actually mean? Like an overarching view when a client comes to you and says, I've been served with these documents.
What do I think?
What does that mean?
I think
does it mean
it's on. There's a case
The starting line, the guns
it's in court. It started a case. It's got a number. It's got a date that it's going to court. So, it's moving. And so you need to then take your steps to make sure you're represented if that's what you want on that sort of program or that process.
Okay, and that's your next step to decide, isn't it? To read the documents and then decide what.
If you agree with them,
I want
or if you
it,
don't agree with them. Yes. So hardly anyone agrees with the documents, the orders that they sought. So what you're really looking at, if you go to your initiating application, you look at the orders sought, okay, and there's orders that they are looking for the court to make, and have a read of those, and that will say things like if it's a parenting matter, okay, it might say that it wants the house to be sold, or it wants and each of you to get 50-50, or it might say that the superannuation should be divided, or something like that. Children, it'll usually have an order at the end that we'll talk about later, but says orders that for costs that that you pay the other person's costs, and sometimes on an indemnity basis. That freaks people out. And
that's a whole episode.
It's a whole episode on that, but don't worry about that. It doesn't automatically happen. It's just there in case they want to make the application for costs, I think. So, yes, so of all of those documents, and they'll all be upsetting, and the affidavit will probably have a stack of stuff in that's irrelevant or not true from your perspective, But the thing a lawyer will do, first of all, is look at that initiating application and go straight to the final orders sought and the interim orders sought, so they can see what is the end game. And then you look at it and say, well, I agree with that. I think we should sell the house. So you can say, I agree with that one. And in your response, you can say the ones you agree with. But you mightn't agree that, for instance, that your ex gets 70% of the proceeds. So you might not agree with that. You might say he should get 30%, I'll get 70%, or we should get 50-50. So you go through.
Okay. So keeping in mind that most of our listeners have either gone to mediation, so you can't get filed this, you can't be served this unless you have attempted mediation. Isn't that right? 'Cause to file it, you have to have a certificate proving that you've been to mediation?
With children, they have to, before they can file, they had to have proven that they've been to mediation, or they've got a certificate under Section 60I that says it wasn't suitable for mediation. So you really don't have to take steps. If they've filed in the court, then your primary objective and your primary obligation to yourself is to file your response in time.
And in time, it's 28 days. Is
from
that
receiving
correct?
it. Yes.
Now, 28 days, is that weekdays or is
every
that
day?
7 days? So it includes weekends. So it's not business days. No. So the first thing you need to do is look at the form. And is it 28 days from the day it was served to you, or 28 days from the day it was filed?
28 the day it was served. From the day it was served.
Okay, so have a look at the date you were given it or emailed it, and then count 28 days ahead, and that's how long you've got.
But sometimes if they've taken a long time to give you the documents, say like it's the 3rd of August or something, and they filed the documents on the 15th of July, and they don't serve you till the 3rd of August, you've got 28 days from that date. But what if they have a court date that's within 2 weeks?
What happens then?
You can either try to meet that deadline and file it anyway, or say to the court, I haven't had time to respond and I need an adjournment. And you can say to the other lawyers or whoever's on the other side, let's ask the court for an adjournment because you served me too late and I haven't got my
and that's not fair.
Days. It's not fair. Yeah.
Yeah, and if you did get in front of a judge and say you only had like 4 days to respond, and you said if you're self-repped, you could say to the judge.
Yeah, it's a complicated document. It's a lot to fill in. I'm doing my best, but I'm not going to I couldn't get it done in 4 days or 14 days. I need the whole 28 days. And you say, I'm self-represented and I'm doing the best I can. But it's not fair if I have to respond to this application today where I'm still trying to fill in my response document.
All right, so 28 days is the magic number. Probably a good idea to give yourself a buffer because the court portal, which is what you would have to file it on, can be tricky the first couple of times you use it. And I think we also need to do a little tech lesson, Mum, on how to log into the court portal.
Yes, so that's a whole series, isn't it?
That is a whole. But you go onto the FCOA website and go to the court portal. It's called ComCourts.
COMCOURTS portal, PORTAL, and then it'll tell you how to register. And you can register.
And once you've registered, if you can look for your little court number, it would
on
be
the top right-hand corner of the document. It'll be something like in Adelaide, it's probably ADC something /2022 or whatever year it was filed. And that's the Adelaide registry number. Brisbane is BRC, and then a number, and I think that could be for children mostly. So just look at that number. It's usually a 4-digit number with a /
it's called
and the year.
File number in the top right-hand corner where it says court use only in the document. Client ID, file number, filed at, filed on, court location,
that's
court
right,
date. So you need that file number. And that'll hook you up to anything that's ever filed. Again, on that number, you'll be able to see it in the court portal. So that's really important, and that's something that you need to get on top of. Even consider starting that before you've even started filling in your forms, because you have to wait for them to get back to you to register you. So don't think it's a thing you can do in one day. So give yourself that
and it
buffer.
helps you keep an eye in case there's any other sneaky little affidavits they file just leading up to court and you're not aware of. It's kind of a self-serve, I think, because although they might have to serve you on some things, you get a little heads up because it's on the portal. If you don't have time to file all of your documents, you can file a thing called a notice of address for service and put that up on the portal. That's kind of a placeholder that says, hey, I haven't done my documents yet, but this is my address. You can email them to me. You don't have to send the bailiff round anymore. It also then you should serve that on whoever has filed the documents for your ex, whether it's him himself or whether it's a lawyer, and get that to them. And then you're starting that dialogue.
So when you say it's a notice to address for service, it basically is a very simple form that says, this is my name, this is my address, this is where I want you to send the information. And it's a really good idea. As we've said before in previous podcasts, if you don't want your inbox of your personal email or business email to be full with court stuff, go and create a new email address and have a little alert that comes up every time something pops in that box. So you keep it separate, but you got it all there so it doesn't get lost.
And you put that then in your notice of address for service as the email address. So don't make it anything rude. Like, I've seen sexy52@gmail.com. No, we don't need that. So
that would be awkward because that would be on all the documents.
You don't want anything
really
that says anything nasty about your ex or anything like that. So just a very, very sort of
very simple
dignified
email. Now, the next part, Mum, is if you do agree with everything, what do you do? This is if you do agree with everything.
You just write to the other side and say, I agree with everything. And if you have to file your material, then there's a section in that says which orders do you agree with, and you probably agree with all. I would be very surprised, though, if you agree with the one about costs. So go through and consider it and list all the ones that you do agree. You should then, once you have all your documents ready and you serve them on the solicitors or on your ex, hopefully then you'll be able to identify the common ground. That's why we do all those documents, so you can see, so we agree with this, 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 and this. The only thing we're really arguing about is, in my previous example, the percentage of the house. Or we agree with all of this, but we're 3 or 4 days apart on children's matters.
All right, so let's go back to just the practicalities. You've got 28 days. Leave yourself a buffer. You've logged into the court portal. You've got a username and password.
You filed a notice of address. What are the forms
that you have to do?
All right. If it's parenting, you have to have a notice of child abuse, family violence, or risk. Okay. And then if you're seeking, and in property orders,
and a parent questionnaire.
Yes. I was just thinking. So parenting orders. These are the documents. notice of child abuse, family violence or risk, the parenting questionnaire, an affidavit, your response document, and genuine steps certificate or statement, and also if there's any DV orders in place, you must file them. Sometimes the other side doesn't put them in, and the court know about them. So it's a lot of work.
And why is that? Can I just stop you there? So some of our DV ladies from some of the hubs might be listening. Why do you have to file DV orders? Because they're already in the court.
No, they're not.
Aren't they?
So they're done in the state courts. They're not done in the family courts. And at the moment, the family court's a Commonwealth court, and at the moment they don't have free-flowing orders between the two of them. So someone has to get their order from one court
the most
and put it. It's
ridiculous thing I've ever heard.
And there are really remembering you've got states who are a little bit sort of protective of their jurisdictions, and they're reluctant to give the Commonwealth more power, and things. And all the states have to make an individual agreement with the Commonwealth government. So it's unwieldy. It'll happen, I think, but at the moment it's up to you, or it's up to actually the person who filed. If they've already filed it, you don't have to.
But if you've seen they've filed and there's no mention of a protection order or any DV things that have happened that the court has given you an order for, it's your responsibility then to file it.
You attach it to something. You attach it to the application, or you attach it to your affidavit.
To the notice of risk.
To the notice of risk.
Okay. So the response to the application, Mum, you said is very straightforward and easy, but I think when looking at it, it's not if you're not a lawyer. So we are going to talk you through that in a video lesson if you're interested, which will be available on our website shortly. But in that, the notice of child abuse safety thingy, that form is pretty self-explanatory.
Notice of child abuse, family violence or risk. Yes, it's pretty self-explanatory. I had someone the other day who put not applicable instead of no or yes. You need to say yes or no to a lot of the questions, and you need to raise your specific incidences and things in that document. You can be sure the court goes back to it a couple of times, and so will anyone acting for the other side and even acting for you. And if you raise an allegation later that didn't show up in your notice of abuse, but happened before you filed your notice of abuse, then that you could have trouble getting people to believe that that's a genuine issue, so.
Right. Yeah. So when you do go to file your response to this documents you've been served, you will realise if you're doing it yourself on the portal, it will say you need to file this form, and it'll bring it up for you, and you can answer it on the online, or you can go to the FCFCOA website and download it and then fill it in yourself and then upload it again. But it is questions about what's happened to the children, what their names are, what dates incidents occurred, have you reported it to the police, that kind of thing. That is going to take a little while. That's going to take at least half a day if you've got lots of incidences.
It's a half a block of chocolate and two cups of tea, I think.
Yeah. Yeah. So be aware that this isn't this is why there's 28 days. Now, the next one is the Parenting Questionnaire. And the Parenting Questionnaire does kind of overlap and has similar questions, but it's what are the names of the children? What are their bedrooms like? What do they share? What are their interests? What entertainment do they have at home? There's a lot of those kind of questions, which we'll also do a little video on how to fill it out. But it is pretty self-explanatory. You don't need a lawyer to help you do that, but you can ask someone, but you can do it yourself. Yeah. And then it comes up to affidavit, why do we need to file an affidavit with a response?
Okay, so all evidence in the family court, all primary evidence is given in affidavit. So we don't have people up in the witness box telling their story for the first time to the judge. Everything is by affidavit. And so you have to swear on oath pretty well the things that you've talked about in the notice of family risk and violence and also in the parenting questionnaire. You have to swear on oath about your circumstances, what's happened when you're separated, how the kids are, their ages, what the issue is, and why you think that your orders are the ones that the court order make rather than the orders, or why you think the other person's orders aren't going to work or aren't good for the kids.
Okay, so this affidavit that you file with your response application, which we'll talk about in a minute, is basically supporting the reasons for what you've written as the orders that you want, as opposed to the orders they want. Can that affidavit also be used as a response to why some of the orders they're asking for are bad? Or sorry to interrupt, but we have a great new product that I'd like to share with you that might just help you fill in these forms. We totally get it. These forms feel like they're written in a completely different language. For just a small amount of $10, you can get our 45-minute lesson guide where Mum will talk you through each question that comes along in the response to initiating application form. If you're trying to fill in this form and you're pulling your hair out, jump onto www.thedivorcecourse.com.au and download our $10 video that guides you through how to fill in this lesson. Have a family law specialist of 35 years telling you what all these crazy words mean and guiding you through answering every part of that form. If you're interested, jump to www.thedivorcecourse.com.au, stop pulling your hair out and feel confident and empowered in going through your divorce journey. See you there. Can that affidavit also be used as a response to why some of the orders they're asking for are bad?
Absolutely, yeah. And it's kind of the foundation document, really, of the Notice of Risk and Child Abuse and also of the Parenting Questionnaire, because if you're putting that stuff in those two documents, Notice of Risk and Parenting Questionnaire, you should back it up with sworn evidence in your affidavit. I think the reason the court does that questionnaire is for a quick snapshot of the parties' circumstances rather than having to read through affidavits which put things in different order, different people, different ways. And but it's not sworn evidence as such. And so they need it in an affidavit.
Now, one question that we also got asked recently said people have been served with a bundle of documents or they've been emailed it, and that, like you said, it can be upsetting. And I think a lot of people don't focus on the order sort. Lawyers might, but a lot of people focus on their ex's affidavit, which could be just full
How dare
of
they?
hurtful
How
things.
could they say that? He knows that's
or
not right.
A conflicting view.
Yeah, that's right.
Yeah, so that, the upset, hurt situation. And I know for a fact that one lady asked, in my affidavit, do I use it to respond to all of their lies or all the stuff, or what do I, how do we focus?
So your affidavit tells your story, right? And then in response to the husband's or ex-wife's, whatever affidavit, I say this, and then you go through and say, I disagree that we separated on this date. In fact, we separated on that day. I disagree that that person did most of the childcare in the house. That's not true. And just generally clear up the things that were wrong. Often I find people, they get that affidavit, they're tremendously upset. And before computers, they would come in with red writing all over the ex's affidavit, and a lot of them were swear words. And I'd go, oh, dear, that's got to go on my file. But now, but even so, now they're getting them electronically, it still hurts and it's still wrong. And they'll often feel terrible until they've got it all, their side of the story, in a similar document, and that gets filed and then they feel like the record's been corrected. So, yes, it's both.
But it's also it's both, yeah.
But
so the headings would be in response to the father's or the
I
mother's
do that
affidavit?
towards the end. I wouldn't let the other side carry the narrative. I think you put
so what do you mean by that? I think that's important that you – so how do you not let the other side carry the narrative? What does that mean?
So if the affidavit will be like their first salvo in their case, right? And it might start off with when little Johnny was born, my ex had postnatal depression and I don't think she's ever gotten over it. She's had mental health plans and da-da-da. So their narrative is that you can't cope as a parent. And if you do an affidavit that starts off with, that's not true, yes, I had postnatal depression, but it was only for 2 months and I could do all of these things, that's not true. Like you are kind of being defensive, whereas you would be better off to say, your truth probably is more to the point was I was a little bit taken aback by how unsupportive my partner was, and I had to do all of the work myself. He never got up at night, etc., any of that sort of. But I've been taking the kids to school, and now I'm in a routine, and the children are comfortable with me. Here's their report cards. I'm managing fine. That's you taking the narrative back. And on the contrary, my ex doesn't, he's been working away. I've been doing most of the work. So you just reshape the argument so that the judge doesn't think it's all about your mental health. No, here's all the positives. Well, the kids are doing well at school, and this,
Okay, so basically it's like writing a story to the judge for the judge to understand what's going on, and if you just spend the whole time being defensive about that one issue but not focusing on any other issues that maybe your ex-partner won't bring up because they don't want to bring it up, then you are letting them get away with the story.
They're carrying the narrative. Yep. They're making up the story the way, and the judge will read theirs first, and if yours just follows on in that theme and doesn't give anything positive, like you say, anything that's really your side of the story, then that's what he or she is working with, and it can change your whole case.
Now, we have done a whole episode right back at the beginning on affidavits. So if you are interested, go to the show notes and click on the affidavit episode, or you can jump into the podcast and just look for the affidavits. And Mum gives you a good rundown of how to make sure you keep the emotion out of it if you're doing it yourself, and what headings and what you should be focusing on in an affidavit, because an affidavit isn't just a big "Dear Auntie May, this is terrible, my life was horrible, he's a bad person or she's a bad person." It's meant to be focusing on what the judge will be looking on, which is the Family Law Act section. I never remember. What's the section? 60
CC for children. So in section 60, literally the judge, if they're going to make a decision, they've almost in their minds, if not in writing, have got a checkbox. And every paragraph, does this apply to anything that I can use? The judge will be saying, I can use all of these issues in section 60 to talk about, to make my decision. Wishes the children, family violence, all of those things. But it's going to be hard for the judge to sift through a whole lot of Dear Auntie May story and apply it to the section. So what I like to do, and I was taught this in law school, is use the section numbers in your affidavit. So when he goes, what did they say about the views of the children? Oh, I see, section 60 CC1, views of the children. And there you go.
There you go, laying it out black and white for the judge. Now, we're going to talk about the response form in a minute, but let's quickly look at property because it's the same form.
It is the same response.
So you need the response application form for property, but what different documents do we need to file for that?
In this one, you don't need the Notice of Child Abuse, Family Violence or Risk Questionnaire, but you do need to file your domestic violence orders if you have any. That is because I think the court can tell if there's any coercion or uses that to just raise that flag of coercion.
Yes.
Okay. They also have to file a financial questionnaire, and it's a little bit like, who do you work for, how much do you earn, all that sort of stuff. And then they've got to file a financial statement. That's a different document. And that one is quite a detailed listing out of your finances on a weekly basis.
Well, that sounds like that would take at least a day in itself to do that. If you don't have a written budget already in your back pocket, it's asking you what your expenses are, what your assets are, how much money you make, how much money you spend.
Well, you spend a lot of time converting.
What your car is worth.
You spend a lot of time dividing your registration payments up into weekly, or, and your school, and trying to work out how much money you might be spending on kids' schooling and clothes and stuff.
Okay.
So there's a lot to be done. So
that's important to remember. Now, so if you haven't been served any papers yet, but you think court is coming up on the horizon, it might be a good idea to check out the financial statement document and just start, keeping a note of how much you're spending on certain things, and maybe when you do get filed with it, if you do get filed with it, it'll be easier for you to fill in and less stressful.
And don't forget the magic E. Do we do a lesson on financial statements, Laura, or is that in the?
We did that in our webinar for mediation, because you have to do that for mediation as well. Right. But I believe we will have to probably do a lesson on how to fill in the financial statement and the financial questionnaire
as long as our voices hold.
So for property, you have to do a response form application, the financial questionnaire, the financial statement, and any DV, and file a genuine step certificate.
Yes, and
to show
an
that
affidavit.
And an affidavit. Okay, and so an affidavit for property would have a different
slant. Yes, so it's Section 79 of the Family Law Act, or Section 90 if it's de facto. Just look through there.
Okay. And that's the contributions and that kind of thing that we've talked about in our property episodes.
Yep. So they go through, and the de facto 190 or one of the Section 90 something. But anyway, it's the same as Section 79 only for de facto. So it wants to know date of birth, what you're earning, so looking at your financial questionnaire will probably give you a good clue as to what needs to be in there.
Right.
You need to talk about the history of the relationship, who had what at the beginning of the relationship, what money you brought in during the time that you were married, what's been happening, or in de facto, what's been happening since you separated, who's done what. You will need to mention the kids a little bit there because the parenting contributions can be reflected post-separation in a slightly larger share of the property pool.
Okay, and that all that information, if you're interested, we talk about that section of the Act and what the judge looks for in our 3-part episode on sorting your property settlement, and we talk about all of those things over 3 episodes. So if you are doing that, go and have a listen to those 3 episodes.
They're podcast episodes. Yeah. How long ago did we do those? Sometime. Last year.
I think.
Okay.
So, but they're our most popular, actually.
Oh, are they?
They're most popular episodes. Okay, so then you've done 28 days worth of work. You've written all of this out. You've listened to the Affidavit podcast. You've watched how to fill in your response form.
Filed it on the portal.
Let's have a... No, we're going to talk about it. You filed it on the portal. But let's have a quick chat about the response to initiating application.
Okay.
So that's the name of the form.
That's the main document on both of them. Yeah.
Okay. And one thing I think, as a reminder to everybody, the parties, which is Part A, it says full name of applicant and full name of respondent. Can you just remind everyone who's listening who's the applicant and who's the respondent when you have been served the documents?
You are the respondent. You are responding to the application to the court, and they are the ones who first went to court. So they've applied to court and you're responding.
All right. So then you're filling in which type of orders you're seeking, whether it's parenting or financial, and then you're writing about your final orders that are sought. So
leave that till last. I think leave that till last because you can disappear down a little rabbit hole there and never come back up. So I'd suggest do the easier stuff first and then
do all the other documents first.
And then think about the orders sought. And that might be where you need to go and see a lawyer, or maybe ring up a lawyer and just get some advice about what you're seeking. So can we leave that?
And it's pretty clear. Yeah, we'll leave that. But it is pretty clear. It's asking, which orders do you agree to? Which numbers of their orders do you agree to?
That's great.
And which ones, which ones. So it's, it does seem quite, it's quite
deceptively easy.
Overwhelming. Yeah. No, you think it's easy. I think everybody who's not a lawyer is like, what do I put in this box? What do I put in this box? What am I meant to write here? So it can seem very overwhelming, but once you have filled in all those documents, which will take you more than a day, so don't leave it till the last minute or you will regret it. Once you have done it all, and we're going to do a little checklist so that if you would like to get that, you can check it off as you go. Then you get it sealed. What does sealed mean, Mum?
Oh, my gosh. I just saw the word interlocutory orders. Why did we put that in those documents? On interlocutory.
See, it is overwhelming.
Well, I think at law school they do something with your brain, and when they put it back in again, you just can't think like a
normal words.
And you say things like interlocutory. And I'm sure lawyers are the only people, along with police, who refer to motor vehicles. Oh, I'll just get in my motor vehicle and go down to the shops.
Yes.
So
interlocutory means interim, which means it's not the final order you're seeking. It's just what you want now.
For the time being,
Yes. Okay. Thank you for clearing that up. Okay. So getting your document. So you've filled it all in. You've signed it all. With your affidavit and your response, you might have had someone to
witness it and sign it.
Witness it. So that's a JP. Sometimes they're at the shopping centre, or you can get a lawyer to do it, or a solicitor. Okay. You've then learned how to use the court portal. You've uploaded it onto the court portal.
If you've got that far.
You've paid money.
Yes.
As you upload it onto the court portal, it won't let you file it unless you have put those documents with it.
Yes.
So it'll say, have you got your notice to child risk?
Yeah.
You have to upload it, and it'll give you a little green tick. Have you got your questionnaire for parenting? Upload it, gives you a little tick. So make sure you've got all of that ready before you waste your time trying to file it all. It will file it all in one big go. You'll press the go button, and then it'll come up with the seal on it, which is basically just a stamp, right, Mum?
Yeah, and it comes from the very old days, Laura, where the old sealing wax that the kings would have, or someone would have and you would burn some hot wax and then put your sort of carved seal in it. And the court sort of did that for a long time. Now it's just a rubber stamp. Well, it was for a long time a rubber stamp, and now I think it's electronic. But it looks like
it's a red JPEG.
It's a red JPEG.
It looks like someone stamped it.
There we go.
So it's been stamped,
that's
right?
stamped,
so
and
you've
that
got
means
a red
sealed.
stamp.
Yeah, a stamp
that means
is a
sealed.
seal. Yes.
Okay, and then
that's not all.
You download it again. So you've got non-sealed, which doesn't have the red stamp, and then you have sealed, which does have the red stamp. And it's pretty much instantaneously that it does it. Download it, and then you have to serve it on the other side. Is that correct?
Yes, that's correct. So we've sealed it, we've been served, we've received it. We've got it sealed, which means stamped, which means has a red circle on every page, and it'll usually say a date that it was filed, and it'll probably give you a court date as well, or it'll have the same court date,
Because it's a response,
And then you have to serve it again. So you've got to serve it on the other side. So look at your application that was served on you and see who it is that you have to send it to. It's right down the bottom of the front page, and it will say who the person's filing this document and notice of address or what address for service. And if it's got an email address, you can email it to those people by way of search.
And that would be easier, wouldn't it?
A lot easier.
And what do you write? What do you write in the email if you're serving it?
Sirs, madams, and put your file number, 5016/2022, and then put your name and your ex's name, so Smith and Godbold, and then put I enclose by way of service. We say that, or here by way of service. That's another old phrase you should use. Are my documents filed today or sealed today or sealed yesterday? And then I would number them. 1, response to initiating application. 2, notice of child abuse or risk. 3, a parenting questionnaire. 4, genuine steps certificate. 5, domestic violence. Oh, no, you'll have the Domestic Violence Act attached to something. And if it's property and children, you'll also have to file a financial statement, a financial questionnaire, and an affidavit.
Okay, so that means you've done all your job.
Yeah.
And then you go wait for the court date that's in that box at the top right-hand corner of the form, and you go either into the court or you maybe wait for the lawyers to write back and say, oh, we like your idea better. Is there any talk in between waiting for court? Is there any discussion between that when you file it and then when you get to court?
Yes, of course. So we're talking only final orders here. The interim orders, there might come up to be an actual hearing. So we've talked about the final orders. If there's interim orders, the very first time you go to court might be for the court to make a decision on those short-term orders. So, yes, there's a lot that goes on. So their lawyers might write without prejudice, which means you can't use it in court, and say, look, we see we're not too far apart on this point. My client's prepared to agree to perhaps one more night in the short term, and then we'll see how things go at the trial. And you might go, oh, that's one more night more than I wanted, but still, I'll agree to that. And then you can perhaps, if you're lucky, be able to either tell the judge on the day that you've reached agreement, or if you've got lawyers on the other side, they'll probably draft up documents that you can sign and send in and avoid having to attend court on that day.
Would be great.
Yes, so the central practice direction actively requires people to try to settle things and to be sensible about stuff. Given that judges could go either way on the day, there's no fixed answer for anything. Really, there's usually a range that if what they're proposing is somewhere in the range of what you might get, you might think, look, I'd rather just save my money and have sort that one out and, then see how we go at the trial.
Now, our ambitious plan was to go through each document in depth and talk about, all of the things, what happens next, all of that kind of stuff. But it is so much to take in. But I think thank you for just sharing a broad overview of, to anybody who has received an initiating application that's been served on them and their minds exploded because they've seen all these documents and they're like, holy heck, what am I going to do? Can I ask, how much roughly would it cost for someone to get a lawyer to do these documents in response?
Maybe $3,500. Would you want them to appear at the court? That would be more, but they might help you draft the documents in response. So I'm thinking that's about 6 hours, 7 hours work. But really, most of that work, any sensible person, I think, can do it themselves with the help of our checklist and our podcast. But you would want to, I think, go and see a lawyer to make sure that the orders you're looking for, the orders sought, SOUGHT, which means orders looking for, that they're a reasonable response and that you're likely to be able to get them. Like you might want supervised time until the child is 17. That's never going to happen. So you need a judge to say to you, no, you know what, that's not going to happen. There'll either be no time or there'll be, supervised time for a briefer period of time. So they can just reality check with you, or you might want
because you might 90%. Not know.
Oh, well, you won't know the law. What 90% of the assets, and a judge might say, well, actually, a lawyer might say, actually, the court won't give you that. I can't see any case where the court would give you that. Or you might say, I don't want to touch his super or her super. I've heard that a lot. Oh, I'm not touching anything that he had when we were married or whatever. I'm not touching anything bought with her over time. Well, a judge, why do I keep saying judge? Your lawyer will be able to say, no, actually, you know what? It all has to come in, and they can say, you're doing this for your future and the children. You might have the guilt for some reason for breaking up, and that might make you want to have do an arrangement that's not in your best interest long term. So the lawyer can reality check you and sort of shuffle your orders around. But you normally wouldn't want to be paying a lawyer to fill in your full name, your date of birth, the date of marriage, the place of marriage, each of the children.
And the notice of child abuse and the parenting questionnaire and the financial statement, they're going to have to ask you the questions anyway. They'll ask you, then type it in
and
for
then
you.
Put it in for you. And
so perhaps maybe do it yourself and then go see a lawyer to check.
With a lot of our clients, we send them those documents if they're not overwhelmed. If you can't think straight, if you are so distressed, you might have to pay a lawyer to do it. But, with the help of like a plan and setting aside some time each day, put some nice music on and just work your way through it.
Just tackle a little bit a day and then get through it. You've got basically nearly a month to do it.
That's right.
But again, remembering that if you file that response, that is what you're saying to the judge that you want. So it is a really good idea to see somebody at least once to get their view, so that you know that you're not going in there asking for them to take you to the moon, which is never going to happen, and wasting your money and time.
Or if you put in orders that are almost too good to be true for the other side and they agree with it, then you're stuck with it.
Stuffed.
So you be careful what you ask for, because you just might get it.
Okay. So it sounds like in that time, the 28 days, you probably also need some reflection time to just kind of really dig down there and make sure, am I not wanting to get what's fair because I feel guilty because I broke up with them? Am I not wanting to do what's right by the children because I feel bad? All these things you need to ask yourself and really reflect, and maybe have a chat with a family friend or a psychologist, but definitely check with a lawyer at least once you come up with what you'd like.
Absolutely. If you're an organised person, I mean, for me, that would freak me out receiving documents like that as a lay person. But what I would do, I would print them out, find the documents I need, maybe print them out, I know that's old school, or save them in a file on your computer so at least you know. So I'm not going to start those documents today because I'm too upset, but these are the ones I've got to fill in. I know where they are. I'll start on the first one tomorrow and divide them up. It's like doing an exam.
Yeah. And if you are interested, we do talk you through how to do a parenting agreement or parenting proposed orders in our DIY divorce blueprint, and also property. But I think it's important here, if you've been filed these documents and you're freaking out, if you've been the document's been filed and you've been served and you're freaking out, to just remember that's what they're saying and that's what they're asking, and this is your chance to do a response. And hopefully clear up some of those situations. And yes, it seems like a lot of work, but if, like Mum said, if you break it down within those 28 days, you can get it done. And we were going to be doing a fair few episodes based on these forms and this topic so that we can continue to help anybody out there who's feeling a bit lost. But thank you very much, Mum.
Thank you, Laura,
for your time. And we also have a podcast winner to announce, and we'll be doing that next episode because we took all of July off, but we're back.
Well, reflection time was good, and look what we've come up with as an idea.
Exactly. Well, yes, and thank you to our lovely members and listeners who've put through some questions as well. So thank you, Mum, for your time. Thank you, everybody who's listening. Make sure you check out the other episodes related to this, and stay tuned on our website, www.thedivorcecourse.com.au. You can very soon download the video where we talk you through how to fill in the form.
Yeah.
Okay.
Stay safe, everyone. Bye, Laura.
Thank you. Bye.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.